Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. Today, we're turning our attention to a recent Constitutional Court decision that deals with a difficult and frankly sensitive issue, the dismissal of older workers based on age. In both cases, Motor Industry Staff Association and Solidarity, the Constitutional Court was asked to interpret Section 187(2)(b) of the Labour Relations Act, which allows employers to dismiss employees who have reached the normal or agreed retirement age. But here's the tricky part. What happens when a worker has passed that age, is still working because the employer wants them to, and then is suddenly dismissed? Can an employer still rely on that section to justify the dismissal? In both cases, the employees argued that their dismissals were automatically unfair because they had continued working beyond retirement age with their employer's consent. Yet, when they were eventually dismissed, the employers invoked Section 187(2)(b) to justify it. Now, the Constitutional Court handed down 3 separate judgments without a clear majority, which has left many questions unanswered. And while one group of workers was awarded compensation, the deeper issue of age discrimination and how this section should be applied remains unresolved. To help us unpack the significance of this case, we're joined today by Advocate Craig Bosch, a respected labor law expert and author who wrote an important article on this very issue over 20 years ago. So we'll be asking him what this ruling means for older workers, whether it's a win or a loss for labor justice, and what the way forward might be. Craig, thank you so much for joining us today on the Labour Justice Barometer. Before we get into the details about this case and its implications, perhaps just tell us your initial thoughts on the case. Is this a win for labor justice in your opinion?
I don't think so. And I'll say so for 2 reasons. Firstly, because the effect of the judgment is to create some confusion. And I don't think confusion is ever a good thing when it comes to the law and dispensing the law. Secondly, the effect of the judgment is to uphold a Labour Appeal Court judgment which takes a very conservative line on the interpretation and application of Section 187(2)(b) and the extent to which employees can be forced to retire in general. So in general terms, no, I don't think it's a win for labor justice.
So I have a couple of questions for you on the specifics of the case. I think you've expressed a general concern about confusion. And of course, the Constitutional Court has handed down 3 judgments in the case. Are there any aspects of these 3 judgments that do appeal to you or address any of the concerns that you've previously raised?
Yes, I mean, I don't think it's entirely disastrous. One of the positive things, I think, is the first judgment in this case, which was given by Judge Zondo, who, in quite a startling move, I think, directly reversed his own previous position on the interpretation of this Section 187(2)(b). I mean, he'd initially taken a very conservative stance. In fact, the stance which was taken in the 3rd judgment in the Constitutional Court. And he did an about-face on that. Essentially, I was quite pleased to see upheld and endorsed most of the arguments that I made quite a long time ago in that article, I think in 2003. He was quite for expanding or extending the protection to older workers, at least to some extent. So that was a positive thing. It was quite heartening to see that even in the 3rd judgment, which of the 3 was the most conservative, Judge Rogers suggested, although he didn't decide the point, that there might be a requirement for procedural fairness prior to employers relying on Section 187(2)(b). I mean, he didn't really expand on what that meant, but I've also written about this before to say that even though the Section 187(2)(b) allows employers to dismiss based on age and it's a fair reason, that doesn't necessarily mean that there isn't some fair procedure to be followed. What employers might be required to do, and again, this is going to have to be litigated, is to follow some kind of consultative process prior to dismissing workers based on age, to give them an indication of what's coming, when it's likely to come, and to get their input as to whether they should be retired and what the alternatives might be in the particular circumstance. Those are positive things. But as I've said, the upshot of the judgment is that we're stuck in the conservative view that was expressed by the Labour Appeal Court, at least until all of this is litigated again. And heaven forbid it ends up back in front of the Constitutional Court, and they'll have to revisit their own decision.
So you've touched on some of the practical aspects and the potential need for some form of consultation or procedural fairness, which makes sense. So it's good to see that, even in the most conservative of the 3 judgments. From a very practical perspective, what do you think the key implications of the case will be for employers and for older workers in the workplace?
As I've said, the Labour Appeal Court's judgment stands. That allows employers to dismiss based on age really at any point after the relevant retirement age has been reached. So the Constitutional Court judgments, or at least the relevant one, the Motor Industry Staff Association one, employees had an agreed retirement age, and that retirement age had been passed by sort of some 9 months until the employer decided that it wanted to retire them, dismiss them based on age. And it allows employers a lot of latitude to get rid of employees on a whim almost. I mean, fair enough, the reason has to be age, and that must be demonstrable on the fact. You have a wide scope and a long time within which to exercise that right. Just on that point, it's interesting because the Labour Appeal Court judgment was upheld and there was no majority on the interpretation of 187(2)(b in the Constitutional Court. The Labour Appeal Court seemed to accept, although it didn't have to rule on it, waiver still plays a role here. While the employer has great latitude in terms of the timing within which it exercises its right to retire employees, it's not an unrestricted right, at least on the Labour Appeal Court's interpretation. So if you can demonstrate in the circumstances that the employer had somehow waived its right to rely on Section 187(2)(b, then the employer can't rely on 187(2)(b. So that waiver issue remains, on the strength of the Labour Appeal Court decision, a live issue. So that's the one thing. And then practically the second thing, I think, goes back to the issue of procedural fairness. And employers are now going to have to apply their minds to what procedural fairness might look like in this context and the extent to which they're going to have to adopt some kind of consultative process. It's not the law yet, as I've indicated, but there's a strong suggestion that this is something that employers need to apply their minds to and to do in practice. And employees on the other side of that, I think now insist, or at least attempt to insist, that employers follow some kind of fair process before relying on their right to dismiss them based on age.
So one of the reasons why Debbie and I were very excited to have you on the podcast today was what you mentioned. You wrote extensively on this topic, and you wrote in your 2003 article, you consider both how to interpret Section 187(2)(b, but also more broadly the arguments for and against mandatory retirement age. So I want to just know from you, tell us a bit more about these arguments and 2 decades later, whether your views have actually changed.
My views haven't changed. And the first point is about how the section should be interpreted. And the second point is whether the section should exist at all. The Constitutional Court dealt with the first point, which is how the section should be interpreted. And obviously, they're different, and this judgment is evidence of that. There are different ways in which the section could be interpreted, and there are different aspects of the provision that could be interpreted broadly or narrowly. For example, what is a normal or agreed retirement age could be interpreted broadly or narrowly. That issue wasn't really an issue in this case, and it wasn't authoritatively decided by the Constitutional Court. The second issue is the issue which featured strongly in this case, which is at what point can you rely on Section 187(2)(b and for how long? And this judgment, or these judgments, show that there are broad and narrow ways of looking at the wording of the section in that respect. And then the third aspect in the section is, what does it mean when it says that a dismissal based on age is fair? Does it mean that it's entirely fair for a fair reason and for a fair procedure, or just one of those things, the fair reason? In where we are now is we're sitting with a very narrow interpretation, as I've said, and I think with reference to the constitutional rights to equality and fair labor practices, and what I've argued is that the courts should have adopted a more liberal, if you can call it that, a more rights-friendly interpretation of Section 187(2)(b with its wording as it stands. And that just hasn't happened, and that's going to have to be litigated again at some future date. The second point about mandatory retirement ages in general, which is what 187(2)(b supports or allows, I think mandatory retirement ages are unconstitutional, contrary to the right to equality, and I would suggest the right to fair labor practices. And that's not something which has been teased out in the courts yet. And nobody's brought the constitutional challenge, somewhat surprisingly, I think, because in other jurisdictions, this has been a much hard-fought territory. And retirement ages have, in the main, been done away with, mitigated to a large extent. There's a very useful, if people are interested, doctoral thesis by a man called Reuben Orton, where he discusses at some length the constitutionality of mandatory retirement ages and Section 187(2)(b, and he concludes, I think, quite compellingly, that they're unconstitutional. And that's a battle which is going to have to be fought at some point in the future too.
When you mention comparative jurisdictions, could you just elaborate a little bit more on that? What are other jurisdictions doing on this area and how are they interpreting this, especially in their law?
Some jurisdictions have done away with mandatory retirement ages. In the US, for example, doesn't have a sort of a governmentally imposed mandatory retirement age. Other jurisdictions also have done away with them completely, whereas others raise mandatory retirement age or mitigate them in the sense that employers can impose them, but there's certain requirements that they have to adhere to first. The general trend globally is I think an acceptance that they're not held, that they do unnecessarily confine right. Ultimately, it wouldn't surprise me if they're done away with altogether. But there are still jurisdictions that have them. Again, if people are interested, there's an exceptionally useful case judgment by the Supreme Court of Israel, where the court has this extensive discussion, the various views and aspects and issues relating to mandatory retirement age, and concludes mandatory retirement ages are an unacceptable restriction of right. The decision was one for the government to make, and the court wasn't going to intrude on the terrain of government, and so it was prepared to allow them latitude. Ultimately, it's different in different places. The issue isn't finally resolved. My view is, in the South African context, there's no need for them. In light of our constitution, they're unsustainable.
You're listening to the Labour Justice Barometer, and we'll be right back.
What could be done differently? Should the Constitutional Court have gone some way to address the concerns? Of course, you've also hinted at the limitations of the judiciary, and some of these decisions are for the legislature. So, the Constitutional Court, of course, had within its mandate the interpretation of Section 187(2)(b). Do you think that this is a matter that we are going to have to wait for jurisprudence on Section 187(2)(b), or do you think that some law reform is required? You've hinted at strategic litigation. Maybe it's a retirement project for some of us. What are your views on how to achieve greater clarity and perhaps policy change here?
I suppose if there's going to be legislative change, it's going to have to be brought about in one of two ways. That the first would be, via the usual lobbying and discussion, and somehow compelling via civil society means, I suppose, and others. The legislature to revisit the provision in 187(2)(b). The other way of facilitating legislative change is a constitutional challenge, getting the Constitutional Court to find that 187(2)(b) is contrary to the Constitution and that it needs to change. Apart from changing the legislative framework, resolving the issues which remain after the Constitutional Court judgment can only be done by way of further litigation. We know that at least some of the Constitutional Court was unhappy with the status quo. That view didn't prevail in the end, but it leaves the possibility of convincing the court on some other occasion that the current law is wrong and should change. And this is the difficulty thrown up by this decision. It's awful in a sense that it doesn't give us a definitive answer, which means that different views remain live in a sense and can be vindicated by way of proper litigation. In future, these issues are going to be litigating their way through the courts until ultimately we end up in the Constitutional Court again, and they can give us some proper definitive view. And then we know.
In our previous podcast, we spoke about the draft dismissal code that was published at the end of January, still open for comment. Do you think there's some scope for providing clarity through the dismissal code, perhaps?
If one accepts that some kind of procedure is required prior to retiring an employee because they've reached a retirement age, the code of good practice would be useful. My sense is that parts of the code relating to operational requirements dismissals would be the most pertinent. I mean, I wouldn't imagine you'd require an extensive or complicated process, but some kind of indications from the employer that this is what we're thinking of doing, and i.e. retiring. We haven't made a decision yet. Give us your input as to what you think we should do and why we shouldn't retire you, I suppose, and what the options might be in the circumstances, and have some kind of consultative discussion.
A nice way we like to wrap up our podcast episodes is just going straight to the title, which is looking at our Labour Justice Barometer. Just to give you a little brief explanation on how this works, and before I ask my question, we have 3 stages in our Labour Justice Barometer. It's either the red, which means that, the decision or the judgment was unfair and possibly a step in the wrong direction. We have orange, which means it was semi-fair, it complies with the law but misses some aspects. And then there's green, which means that this decision was fair and progressive. So using our Labour Justice Barometer, how would you rate this judgment in terms of fairness and protection of workers' rights? Does it strengthen safeguards? I mean, you've already spoken about this a bit, but maybe you can incorporate this as well into your decision. Does it strengthen safeguards against age discrimination, or does it just introduce new risks for older employees?
I'd rate it orange, I think, for the reasons I've given. And just to be clear, it's a conservative, the outcome reinforces a conservative situation in the sense that employers have great latitude to retrench employees who've reached a retirement age. There's some positive things which come out of it in the form of the first judgment by Judge Zondo, which is very employee-friendly, and these suggestions that there must be some kind of procedural fairness prior to employees being retired is also a positive. So there's a mix, and so for those reasons, I'd rate it as an orange and not go so far as a red.
Craig, thank you so much for joining us today on the podcast and for your insights in this complex area of law and policy. As mentioned, we will leave links to resources that Craig has mentioned.
I should just add one more thing there. Craig, I think what this podcast has told us is that you need to now write another article on this. We need to have an update.
Thank you. I'll get on it as soon as possible.
Thank you so much.
Thank you for having me.
And thank you to Debbie as well. And all our listeners are welcome to comment or ask questions or suggest cases that you'd like us to discuss. Please, once again, leave us a comment on Spotify or LinkedIn. Debbie, as always, it's been great. Thank you again.
Thank you, Asha. Chat to you soon. This podcast is not intended to constitute legal advice.